Okay. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the single justice of the Massachusetts Appeals Court, now sitting virtually within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to this virtual hearing of the Massachusetts Appeals Court. We are hearing one matter today, and that is 22J88 Bees LLC versus Harold et al. If the parties would unmute themselves, we are here on a hearing pursuant to General Laws, Chapter 239, Section 5, regarding review of an appeal bond order. And Mr. Harold and Ms. Bergstrom, will both of you want to speak? You're both named and you're both entitled to, or will one of you be speaking?
I'm going to let Deborah speak for us, Your Honor. Thank you very much.
Okay, so she's not your lawyer, so she can't speak for you, but you're going to adopt everything she says unless you tell me differently when she's done talking?
We've been over this, and I know better than to.
All righty. Ms. Bergstrom, tell us what you want us to know about the appeal bond order. Let me just say that I noted that the judge found in your favor on the issue of indigency, and it appears that the only issue is whether or not you have a non-frivolous issue on appeal.
Yes,
that's my understanding. So
yes,
go ahead and tell me why you have a non-frivolous issue on appeal.
Okay. The statements in the judge's decision, the housing court judge's decision on February 18th, he states that one, our reason is frivolous, two, the appeal issue is a new legal issue, and three, the town of Shrewsbury needed to authorize the eviction. The reason for appeal is that the Attorney General's Manufactured Housing Community Laws and Regulations, 940 CMR 10.0, have not been applied since the beginning of this case, despite our repeated attempts to apply the law. Specifically, the definition of substantial violations, 940 CMR 10.00, Section 2, subsection K 2B, and 940 CMR 10.08, Section 2B. The process of eviction, 940 CMR 10.00, Section 2, subsection K 2C, 940 CMR 10.08, Section 3A, and retaliatory eviction, 940 CMR 10.08 4A, and the defenses under 940 CMR 10.0, Section 2, subsection K 4D, 5, and 11. These laws are specific to manufactured housing communities because of the unique situation that tenants own the home and rent the land it's on. I can go on further if you would like me to paraphrase the law, what it says.
Can I just ask, was any of this, I don't have the trial transcript in front of me. Was any of this that you're speaking of now, your references to various CMR sections, were any arguments at all made at trial or on the motion for reconsideration regarding the applicability?
We had an issue. Oh, sorry. Go ahead. Finish.
Regarding the applicability of the Code of Massachusetts.
We did bring this up. We had a pro bono attorney at our trial, for our trial. We brought up the issue that this was our defense. This whole thing was our defense. He really, we felt we had misrepresentation after the trial, and I did let community legal aid know.
I understand.
He didn't bring it up.
Ma'am, I understand that. I'm just asking a much simpler question. And
okay.
We'll get to that. You can tell me anything about that you want to, although I should say to you that we're going to be confined to what's in the record, but I know that can sometimes be hard. But the only question I'm asking right now is, were these arguments under the Code of Massachusetts regulations raised at trial or in the motion for reconsideration before the judge?
Okay, the trial, he did not raise it in testimony. Our attorney did not bring it up. The judge was aware of that this is a manufactured housing community. but we do not know what our attorney presented as evidence. He never went through it with us. In the motion, I did not write it in my motion, but I did try to read the law to the judge, and he stopped me and said I didn't need to read it. He knew the law. So I did bring it up in the motion to reconsider.
So you're saying you didn't put it in the written motion, but you raised it at the hearing? Is that what I hear you saying?
Yes. I didn't know I was supposed to write it in the motion for the law to be applied. Being pro se, we were pro se at that time.
If I may interject, Your Honor, now that we've changed the subject off of the original,
Appeal bond.
off the appeal bond.
Well, we're not off the appeal
Well, we're
bond.
not off it, I know, but
I'm
there-
only considering the appeal bond, and I'm only trying to decide whether or
Mhm.
not you have a non-frivolous issue on appeal. And I hear you both telling me that you think this issue of the applicability of the CMRs is a non-frivolous issue. So I was just trying to
yes.
Okay.
get a
yeah.
sense of whether or not, the motion and the trial judge had had a fair opportunity to consider this below. So let's keep to the appeal bond.
Okay.
Mhm.
But what are the non-frivolous issues that you have? on
Well,
appeal?
the law, the applicable law was not applied.
When, Your Honor, if I may, when we mentioned the town of Shrewsbury, in the law, when this law was written in 1976 and then revised again by HUD, I believe it was in 1997, the law was written so that the landlord could not just get one or two individuals from the park and bring them into court in order for them to testify against you, because that would be like stacking the deck. So in their wisdom, they decided that somebody from an agency would have to take over, which would be the agency, which would have to be the health or the building inspector in regards to the unit,
Or police.
or the constable, police, or sheriff. And in this case, we have police. And because there was no police called and this was brought into court, we assumed that our attorney would just say, well, you're missing one big component here, which is the main component of not having a agency backing up with some paperwork. In other words, a police report. And so we kind of thought the judge would take that into consideration as part of these CMRs, as well as the way everything was written up. There was also one thing added afterwards, after the original eviction. This wasn't about rent being not paid. It was about rent being withheld. That was never brought up as to whether or not we had taken enough or not enough. But we did follow all the bylaws, which is open an immediate account at our credit union. All the monies that are being adjudicated that we pay, we have that right on hand, so that's not an issue. But basically, we felt as though when we went into this pro se and then got this pro bono attorney after the mediation, that somebody would say, yeah, you're missing a huge component here. Because as they testified prior to this, and we've been here 15 years, 17 years, there was zero issues, and it takes 2 issues within a 6-month period. And if you read how this all unfolded, it all unfolded on the very same weekend, which again, if you go back to 2008 with the issue with the next door neighbor, without Mr. Seppi's management, there has been prior issues, which we did not get into trial because our attorney did not bring that up. And
Jim is talking about the process of eviction.
Right.
There has to be, a government agency has to be the one to determine a substantial violation. So these laws,
that's what I was getting at.
we trusted our lawyer to bring it up at trial, and then we trusted the judge to apply it.
We trusted the manufactured home bylaws, because we've been in touch with the Attorney General's office since 2019 in regards to issues in this park, in regards to how to change things. one thing I'd like to bring up is the issue of our parking. Well, the issue of the parking, Your Honor, has to be done within a 75-day notification with the Attorney General's office, unless, as it reads, it's a health or safety issue. And just telling me to move my car off the street, which it was there for less than 15 minutes, in doing so, shouldn't have carried forth. But unfortunately, other issues were brought up in regards to permits and things. And we took the heat because we were the ones that were making the stink. And that's where other things just festered.
Yeah, okay.
And here we are today, since August 2nd of last year.
Shouldn't have gone this far.
Shouldn't.
Also, there are instances where the housing court judge has misunderstood the law. You know, in his last ruling on the appeal bond hearing, he says the town of Shrewsbury needed to authorize the eviction, and that is not how the law reads. So, you know, it is not, we believe this is not frivolous applying the law that applies here. And it's not a new legal issue. We've tried to bring it up, and the housing court judge is misunderstanding the law, it appears.
And one other thing I would like to bring up, Your Honor, also in closing with me, is my demeanor was called into question during this a couple of different times. Well, naturally, after being here 15 years, paying faithfully, having this all happen after a beautiful 3-day camping trip, my demeanor has gone down the tubes as far as the process, the way things should be. I'm a Vietnam era veteran, I'm a Grenada veteran. We paid our bills faithfully right on up until the day that we said this has to stop. We need to put a break on here. And again, like I said, we did it all by the book, and we hold no animosity towards Mr. Seppi, Bees LLC, or the attorneys. However, there are other issues with our site and other issues in the infrastructure of the park that still to this day have not been addressed. And when we sent this to our town
department,
the health department, which holds the permit for Bees LLCs to run this park, we got it back again, deferred back to Bees LLC. That was 3 weeks ago. So things are still being plowed up, being ran through. And, you know, again, and I hate to say this, but you can look this up. We've got an asphalt plant, a Part 3 right there, the biggest one in central Massachusetts, which is just mind-boggling to me.
okay.
I'm sorry.
All right, so let me just, I think you've started to go towards the basis on which this was decided. And what I'd like you to do is to think about this in a slightly different way for a moment. Lawyers have this phrase, arguing in the alternative. And I understand that you feel quite strongly about your argument under the Code of Massachusetts regulations. But that wasn't raised at trial. You also feel quite strongly about why it wasn't raised at trial. And I understand that that was clearly presented in your papers. But if for any reason an appellate panel were to decide that it wasn't going to consider your arguments under the CMR, do you have any other issues on appeal based on what was decided in the judge's decision and on motion for reconsideration that you consider to be non-frivolous issues worthy of presentation to an appellate panel?
I haven't really.
First of all, I would just like to say in his findings, mentioning the fact that that we had little or no evidence presented 3 or 4 different times in his first finding, and then in the motions finding, bringing up my demeanor as a catalyst towards his judgment as he writes. I thought that was a little odd because I don't think it's right for a judge to throw in demeanor without knowing exactly how this has affected me, my household, Deborah, how it's aged me, affected. I have a 15-year-old son that lives here. He's a very well-rounded kid. He has to live in Shrewsbury in order to go to Assabet. He's a junior there. He's studying welding. He also works a mile and a half up the road at Shaw's. He's 15 and a half years old. He's got himself a beautiful job.
Okay.
And, losing this
Sir,
place is going to be a pain to us.
Sir, this is matters outside the record, and I very much appreciate you wanting to tell me about it, but I have to be honest with you
Okay.
and
No,
tell
I
you
mean-
that that's not something I'm going to be able to consider.
I understand.
I do believe that the only law that can apply to a manufactured housing community is the Attorney General's manufactured housing community laws. Those
I
are the only
understand.
laws that can apply.
I understand your position on that. Whether or not that argument is waived is something that an appellate panel would have to decide. I don't
Okay.
decide that.
Okay.
Thank you.
Which is why I wanted to give you the opportunity to say here and now what your other non-frivolous issues were on appeal. I understand Mr. Harold to be saying that he thinks that the assessment of his credibility lacked substantial support in the record. That would be the terminology that we would use in legal circles. That can be normally credibility is for the judge. That can be a difficult argument to make, but I hear you that that's one of your arguments. You've got a legal argument and you've got an argument regarding the credibility findings. Before I turn to Attorney Packard, is there anything else that you would like to say about your issues on appeal?
Okay, and I mean, it goes to the point of the housing court judge misunderstanding the law or misinterpreting what we were saying. Also, the fact that at the motion to reconsider, I was cut off from reading the law to him. So, I hope we've said enough there,
Okay. Have you ordered the transcripts connected with your appeal? Have you ordered transcripts of these hearings?
Not yet. I have the audio access, so all I have to do is order them. I wasn't sure of my timeline. I thought I had to wait for this decision to do that.
I'm not sure of your timeline either. I won't tell you that the rules of appellate procedure are transparent and easy, but you'll be getting a decision in this case. So
Okay.
all my ruling on an appeal bond order would be whether or not you'd have to make payments during the pendency of the appeal. It would not affect the appeal itself. It would only affect whether or not you have to make
Okay,
payments.
very good. Yes.
And Attorney Packard will correct me if she thinks I'm wrong about that. And with that, I believe you had a chance, you've both had a chance to say what you needed to say. Is that right?
Yes. We
Okay.
have paid, one more thing, we have paid our rent. We started paying our rent and we are able to pay the appeal bond. Attorney Packard knows that I paid 3 months in advance to save at the teller's check fee per month. So, and paid it to the landlord B's LLC. So March, April, and May are paid for.
And we have the judged amount that you have in a cashier's check, I guess, right?
Yes, I
bring to
have
the court,
I
to
have
bring
the
to the
check
court.
ready for the appeal bond
Okay, so you're able to pay the amount
stated in the order. Yes.
specified. Okay,
Yeah,
that's
no
important to
problem.
know.
Yeah. We
Yeah.
put all that away every month,
Yeah.
like required by law.
So
So,
Okay,
Okay.
all
Okay.
right.
I
Anything
think
else?
that's it. Thank you.
Anything else?
I don't think so.
Okay, because once I'm done, we're not going to do rebuttal. I'm now
Okay.
going to turn
Mhm.
to Attorney Packard,
Okay.
who's been waiting very patiently, and I would just
Yes.
ask that you do the same thing with her. You probably won't agree with what she's saying, but don't make faces or,
Okay.
put your head
Okay.
around things.
I'll try.
Been very
We-
patient as well, okay? And if it turns out I have questions for either of you afterwards, I get to ask them, but you don't get a chance to re-argue. Okay, Attorney Packard, thank you for waiting. I'd like to hear your response on the issues before me.
Good morning, Your Honor. May it please the court. My name is Jacqueline Packard. I represent the respondent Bees LLC in this matter. Your Honor, just briefly with regards to procedural history, this was a matter that began back in on July 30th of 2021, when police were dispatched for an alleged assault at the property at issue. Subsequently, a notice of termination of tenancy and notice to quit was issued for substantial rule violations in accordance with Mass General Law, Chapter 140, Section 32J, as it relates to manufactured housing communities, Your Honor. Your Honor, the petitioner in this matter failed to cure the violations as set forth in that notice, and a summary process case was subsequently filed. On December 9th of 2021, a summary process hearing where both parties were represented by counsel was scheduled and heard in front of Honorable Sergio Carvajal in the Central Housing Court, Your Honor. Judgment subsequently entered for the plaintiffs, and the defendants in that matter did in fact request a motion for new trial and motion for reconsideration of that specific judgment. Your Honor, that there was a hearing on those motions. They were subsequently denied by the judge that heard those. Your Honor, this matter was heard on February 10th of 2022 with regards to an appeal bond hearing, in which the judge set the appeal bond at $2,695, which was the current use and occupancy that was unpaid, as well as a monthly use and occupancy of $385 per month. Your Honor, the respondent would ask that the appeal bond in use and occupancy entered by the lower court be affirmed. It was a reasonable order in balancing the interest of both parties. With regards to indigency, although that is a statutorily defined term under Chapter 261, Section 27A, at that particular appeal bond hearing in the lower court, the petitioner there did provide contradictory information, indicating that they had, and they have indicated here again today, that they have all of that unpaid use and occupancy. The purpose of that statute with regards to waiving of the appeal bonds for indigency is so that the individuals aren't precluded from access to courts by their financial inability, which is not the case here. Your Honor, with regards to the non-frivolous claims, which would be required to waive the appeal bond, the petitioner in this matter has in fact raised issues on appeal that were not raised at trial. They were also not raised at the motion for reconsideration or the motion for new trial. In fact, there were different arguments that were made during that motion for reconsideration and motion for new trial that were in fact not raised here again. Your Honor, their argument is—
Counsel, I'm sorry, I didn't check this. Were you counsel on the motion for reconsideration?
I was, Your Honor.
Okay. And you're saying that the CMRs weren't raised?
Based on my recollection from those hearings itself and review of the record, I did not see that they were in fact raised. The CMRs were mentioned during trial as this was a manufactured housing community, but the petitioner's defenses based on the CMRs was not an issue at trial or the later motion. They did have other defenses relating to conditions as well as retaliation that the judge did not credit and did deny.
So for purposes of deciding whether or not there's a non-frivolous issue on appeal, and I'm focused on that because the judge said that there was no non-frivolous issue. What do I do with the fact that he made his credibility determinations? And I'm sorry about the noise in the background, I can't stop it. What do I do about a credibility determination that's based on lack of corroborative evidence about the complaints, and then the motion for reconsideration attaches the complaints?
Can you repeat that, Your Honor?
The argument that I'm hearing as to a non-frivolous issue on appeal is that the issue of credibility was adversely decided against them based in part on the failure to produce a trial corroborative evidence of the complaints they made, and that they lost on the retaliation claim because of that too. Now they were supplied, albeit late, on the motion for reconsideration. Does that raise a non-frivolous issue on appeal as to the retaliation claim and credibility?
I don't believe so, Your Honor. With regards to the credibility determination that was made, I believe the judge made notes in his findings, both after trial and both after the motion for reconsideration and new trial, that the credibility determinations were based on the testimony of the parties. I believe the judge specifically noted in his order dated January 31st of 2022 that Mr. Harold's demeanor and behavior during trial demonstrated a belief that he was correct regardless of any evidence to the contrary. And the case was determined on the defendant's own conduct and credibility. I don't believe it had to do with the failure to provide corroborating evidence. That both petitioners here did testify at that summary process hearing, Your Honor. They both did, in fact.
I certainly understand that argument on the merits. I'm trying to figure out a different question. And it may be a moot point now that they've said that they can pay the use and occupancy. So this may all be an academic exercise, but it's one that's difficult, I think, for single justice to decide. You're giving me an argument as to why you should win, but I'm still grappling with whether it raises a non-frivolous issue. Are we saying credibility is completely off the table and no appellate panel could ever consider it?
Not necessarily, Your Honor. Credibility can be a factor with regards to a genuine complaint. However, I think the record as a whole has to be evaluated with regards to a non-frivolous claim. I would suggest the court, similar to Avery versus Steele, 414 Mass 450, where the individuals in that case ignored written findings of the housing court and they argued matters in the appeal that were not raised at trial. Obviously, the court needs to consider, Your Honor, ensuring that the tactics used are not purely for the purpose of delay and they are a genuine issue that would be raised in the appeals court, Your Honor.
Okay.
With regards to that, Your Honor, I'm not saying that if it's a novel or unusual argument, it should be classified as frivolous. However, that is not the case here. The petitioners in this matter are not seeking reversal of an existing law. They're also not indicating that a new principle should be adopted. Your Honor, they did not raise these issues at trial or the subsequent motions. Your Honor, in addition to that, they have in fact indicated that they have the funds, and they have indicated today here that they have provided the use and occupancy. Furthermore, I would note that on the face of their motion dated February 23rd of 2022, they did indicate on there that the appeal bond order is in agreement, and then they go into the use and occupancy itself.
This February 23rd order, do I have that?
That was their motion under 239 Section 5.
Okay.
Filed in the lower court.
I thought you were referring to something new.
Your Honor, with regards to the use and occupancy, that was set at their existing rental amount. Because this is a manufactured community, there is a blanket rent, meaning all of the units pay that same amount. It was not set at anything other than that. Your Honor, both the appeal bond and the use and occupancy were reasonable, taking into the consideration the merits of the argument that the petitioners made, as well as the record as a whole. Your Honor, the respondent asks that the appeal bond and use and occupancy entered by the lower court be affirmed and remain in place.
Okay. So I just want to make sure that I don't misunderstand what's happened here and where the parties are. Attorney Packard, the $2,000 plus, was that the back rent that was owed at the time of the filing of the summary process, or is that rent for May to July of this, for a period of more recent period? What's your understanding?
That $2,695 was from the date that the property manager who handles this property indicated that an eviction was coming based on the police being called. through the judge's hearing of February 10th, so through the end of February. So that included August of 2021 through the end of February 2022 was that
All right.
$2,695 amount.
August of 21 through February of 22. So from your perspective right now, there's no arrearage?
Correct.
Okay, so we're only now talking about use and occupancy going forward.
So
Yeah.
that appeal bond, obviously at this point has not been paid. That is the outstanding. They have in fact paid use and occupancy for March. They have indicated that they will not provide anything other than a 3-month check to the property manager and the owner. So they have now paid use and occupancy for March, April, and May.
All right, I'm confused again. Are you saying there is or is not an arrearage?
The only arrearage there is from August of 2021 through February of 2022.
Well, you're saying there's no payment from August of 21 through February of 22.
Correct. And that was the amount that the judge and the lower court set in
All
place
right.
as the appeal bond.
All right, I misunderstood what you said before then. I thought you said that there had been payment. Okay, so there's no payment for that period of time. What was the 2,000 plus paid for then?
That has not been paid.
Oh, they're holding it in escrow
Correct.
and are willing to pay it. Okay. So they're saying they're willing to bring themselves up to date, as I understand it. Ms. Bergstrom and Mr. Harold, you're saying you've got that money in escrow and you're willing to pay it?
Yes, when we initially had these problems on August 1st, we told Bees LLC that we would be putting it into a credit union account, which we have.
Okay,
So we have every month put in, just like we were paying Bees LLC.
so I'll take that as a yes. And you're
Yes.
saying that you can pay the use and occupancy of 385 going forward, and you don't find that to be unreasonable?
Absolutely. That's
No.
fine. Yes.
We paid it for
Okay.
15 years, so it's
Okay.
not a problem.
So the only issue I have before me, as I see it right now, you're not, and I said that I got the right to go back and ask more questions, and you didn't get the right to talk again, and here I am, I'm doing it, but I just want to make sure that everybody's on the same page here. Are you still asking that the appeal bond be waived since you're able to pay it?
No, that was not the issue we brought today. We're agreeable to paying that still and have the check ready to go and bring up
Okay.
there. I didn't want to pay it. I didn't want to pay it till we had this hearing because I wasn't sure if I should or not. So
You
yes,
weren't-
and
you weren't sure what you were asking for, so you were cautious.
well, I wasn't
you-
sure what I
Right.
should
We-
do.
We
Yes.
were cautious
Okay.
because we didn't know if that would be part of the other issues that we were bringing up as far as the frivolousness of
Yeah.
our
All right.
appeal.
So-
You didn't want to
So we
waive your
just-
right, you didn't want to
Right.
waive your right to appeal.
Mhm.
Attorney
Right.
Packard, based on that representation, is there anything else you would like to say to me?
No, Your Honor.
Okay, quit while you're ahead, right? Okay, all right. Thank you all. You've clarified what needed to be clarified. I think I understand this now. And you'll get an order from me within the next couple of days. All right,
Thank you, Your
And what-
Honor.
thank you. I'd like to thank our clerk and our IT department for everything they've done to make hearings like this possible. I'd like to thank everyone who's been involved in this hearing for being so clear in your presentations. And with that, our hearing is concluded.
Can I ask one more question before we go? Just about the decision. Can you ask the clerk if I get that in an email? If I get the decision in an email?
We'll,
Or do we get it in the mail?
we'll find, I don't know the answer to that,
Okay.
but you'll get it one way or another.
I thought the clerk was still there. Okay, thank you.
Okay, take care. Thank you
Okay,
very
goodbye.
much.
much.
Thank you very
Yeah.
much.
Have a
Thank
nice
you.
day. Have a nice day, attorney.
I leave meeting.